Dear colleagues, let's resume the review of the fourth periodic report of the Republic of Korea. We've seen how the delegation was working arduously in the short period of time that we had allotted them in order to prepare their responses. I'll give the floor straight away to His Excellency, the head of delegation, in order to start to hear the responses to the questions raised by colleagues. And then, after the delegation have provided responses, our colleagues can ask follow-up questions. You have the floor, Mr. Head of Delegation.
네, 위원장님 감사합니다.
Thank you very much, Mr. Chair. So the questions that come from the committee are actually including some of the information that would be required after that we had submitted our report. And I understand that there were a lot of questions that were asking for the updates and as well as ensuring some accuracy in terms of the information to be provided. So I'm going to ask working level officials to give the answers to the questions first, and I will add my comments if needed. Mr. Cha Kyung-hwan, who is the Director General of the Human Rights Bureau, will work as a moderator for this session. He's going to designate a person that will be giving answers to the questions. Thank you very much. Thank you, Mr. Chair. Thank you, Mr. Head of the Delegation. I'm from the Ministry of Justice. I'm Cha Kyung-hwan. I'm the Director General of the Human Rights Bureau at MOJ. I'm going to take this opportunity to provide you with the answers to the questions that have come forward from the committee. In order to ensure efficiency in delivering answers to the questions, I will have to intervene from time to time to designate a person that will be giving answers to the questions. Questions will be addressed in the order that were asked. Excuse me, the answers will be given in the order of the questions. And we will also take into consideration the time constraints as well. And as was mentioned by the head of the delegation, at the beginning of this deliberation, we're going to make sure to give faithful responses to the questions. So that is why the delegation is comprised of 39 members of the government agencies from the Republic of Korea. Actually, I think that there were a lot of questions that came from the committee compared to what we had expected before, so we're going to give you very faithful answers to the questions asked. First, answer to the third Rod Lee, member of the committee. The first question was related to Article 22, reservation to Article 22. This question is going to be answered by a person from the Ministry of Gender Equality and Families. Nice to meet you. I am Lee Won-do from the Ministry of Gender Equality and Families. Korea, in terms of freedom of association that is defined by Article 22, we ensure freedom of association by relevant laws as well as the Constitution of the Republic of Korea. However, the Korean government, when the first periodic report was submitted and also when the fourth periodic report was submitted, we explained about our position as to why we had to reserve Article 22 of the Covenant as follows. For those high-ranking public officials of grade 5 or higher, their joining of the trade union is not allowed in the current Korean laws. It is because they're involved in the policy decision-making process, and they also give command and order to the lower-ranking government officials. That is why we classify them as the employers category. And in 2008, the Constitutional Court of the Republic of Korea also supported that position of the Korean government. And therefore, it's difficult for us to withdraw reservation to Article 22 of the Covenant. Thank you very much.
네, 수고하셨습니다. Thank you very much. Next, regarding the implementations of the views expressed by the committee, we would like to invite our staff, our official from the MOJ. My name is Eugene Oh from the MOJ of Korea. You posed a question regarding the decisions on the individual communications. The NHRCK of Korea advised that we establish a special law regarding human rights, and between 2006 and 2007, in order to seek ways to implement the decisions on the individual communications, we have operated a task force, and we considered various ways, and we considered a way of regulating it under the criminal law or establishing a special law concerning this issue and so forth. So various ways of going about it were considered. However, given the domestic legal framework, implementing such decisions was deemed quite difficult to do by law in Korea. Still, regarding the ways to implement those decisions, the review process is still underway. And in addition to the ICCPR, we understand that there are other UN conventions such as the CRDP and CRC, and various arrangements and improvements are currently being made in Korea. As such, we have a plan to review the ways to implement based on the decisions of the individual communications along with such efforts. Thank you very much.
Next question was related to the NHCRK of Korea, National Human Rights Commission. We are going to prepare an answer to the question. So with your permission, we would like to skip to the next question. We'll provide you with the answers later on. Next is related to the definition of torture and how that is reflected in the legislation process. From the Human Rights Policy Bureau, we have a person that will be answering the question. I'm Song Gyu-young from MOJ. Let me answer the question in relation to torture. First, I would like to talk to you about the definition of torture in the Korean legislation. Article 125 of Criminal Code, trial, police, those people that conduct, for example, torture, ill treatment, and if there is any assault against individuals or ill treatment against persons, the person will receive imprisonment no more than 5 years. This is defined in the laws. Those people, this provision is about punishing torture and ill treatment of special public officials who are in the duty of performing public affairs in relation to the custody of persons. This provision is subject to the statute of limitation. Also, in relation to the statistics on National Human Rights Commission of Korea, we would like to, with your permission, provide you with further information at a later point. People that have received disposition because of the torture or ill treatment against individuals in the process of performing public official duties. In 2012, we had one case. 2013, we had one case of a prosecution. And in 2014, one case of prosecution. For 3 people that were involved, 2 of them were dismissed from their duties. 1 received disciplinary measures. These statistics are based on objective data. Next, once torture and ill treatment suspicions whether there is an independent objective investigation process in looking into the charges against ill treatment and torture. The police agency, in order to ensure impartiality in investigation in terms of the charges or accusations that have been filed against police officers, has relevant laws and regulations in place, and make sure that the independence is ensured in investigation by having another police station conduct investigation instead of the police station where the police officer belongs to. So we have an effective and independent mechanism to ensure impartiality in investigation. Thank you.
네, 고맙습니다.
Thank you very much. Next question was regarding torture, whether there is an independent investigation into torture cases and the issue of low prosecution rates. Regarding these questions, coming from the MOJ's Human Rights Policy Bureau, we will provide an answer.
법무부 인권정책
My name is Kyu Young-song from the MOJ. As to the reason that we are having a low prosecution rate for these cases, we will have to check our statistics first before providing you with a more confirmed data. Thank you.
예, 우리 대표단에서도
Thank you very much. The members of the delegation, if some of you wish to provide an answer later on after making confirmation, please let me know. Next question is with regards to the treatment that is given in correctional facilities concerning the issue of solitary confinement and so forth. From the correctional facilities headquarters of the MOJ, an answer will be provided. Thank you. My name is Shin Young-woo from the MOJ. Concerning solitary confinement and protective devices, let me provide you with a response. First, regarding solitary confinement in Korea, if an inmate inside a correctional facility violates a rule or regulation, as punishment, as a disciplinary action, he or she may be placed in solitary confinement. In order to maintain order within the facilities, each of the correctional facility will have its own rules and regulations in order to maintain such order. And if an inmate violates such a rule, and if that action is serious, solitary confinement will be imposed for up to 30 days. In the case of this inmate, once he receives a solitary confinement decision, he will have to be checked by a doctor before actually going into a solitary prison. And even during solitary confinement, exercise, taking bath, and writing letters are allowed. The punishment committee that makes the decision on such solitary confinement consists of 5 to 7 members. And this punishment committee is participated by external members. At least 3 of those members should come from outside the facility. And inmates subject to such punishment will have an opportunity to appear before the committee to make a statement. And such an inmate will have the right of challenging a particular member of the committee if that member is feared to give an unfavorable decision against himself or herself. Regarding the use of protective equipment, this equipment will apply some physical force on the body so that the use of it is regulated by laws and regulations. And there are certain requirements, so I would like to explain about those. First, if there is a significant risk of flight or making a suicide, the use of it is allowed. Only when such risk exists, we can use such devices. Secondly, the use of protective devices is not allowed as a means of punishment. And at the same time, once you use a protective device, such use should be recorded in writing. Furthermore, once there's no longer a reason for use of such device, immediately the use of that device should be discontinued. As such, but there is a control mechanism in place. For instance, there's an audit that's taken place with regards to the use of such protective devices in correctional facilities, and that audit is conducted by a higher level body. And at the same time, if an inmate who is subjected to the use of such a device finds the use unlegitimate, that person can file a complaint with the NHRCK of Korea or file a lawsuit. Thank you.
대표단장입니다.
So let me add to that as the head of the delegation. As for the correctional facilities, solitary confinement or the use of protective equipment, actually we have a lot of debate that is going on in Korea. So through legislation and the relevant laws, we do have a standard system in place to respond to those issues because we have members from outside the facility that have to take part in the process of making decisions for the use of such protective equipment and solitary confinement. And through ensuring such participation, we have to make sure that there is a due process for determining such measures. And second, protective equipment are never used as a means of punishment because whether a protective equipment was used for such punishment, there's always a way for prisoners to file a complaint against such illegal use. That is why there is a low rate of indictment against police. Oh, well, I understand that there was a question related to a low rate of indictment against police officers, those people that are working at the prison facilities, those public officials. We understand that there are a lot of discussions on this issue, and there has been a lot of policy discussions as well. So the Supreme Prosecutor's Office as well as court actually make effort to directly look into these relevant cases. So in the ex post manner, there's a review on the legality of the use of protective equipment. So there's a deliberation that takes place after the use of such protective equipment to ensure due process. Thank you.
네, 감사합니다.
Thank you very much. Sir Lowly posed this question regarding the NHRCK, and as soon as we are ready with the response, we'll give you that answer. Mr. Yuji Iwasawa posed several questions, and we will provide answers to those questions. The first question actually had a lot of points. First, regarding the Korea Minting Printing Corporation and other Korean companies that are operating overseas, the Ministry of Industry and Commerce will provide you answer to those questions. And regarding the infringement of human rights of the foreign seafarers, the Ministry of Marine and Ocean Affairs will give you an answer. And at the same time, concerning the Korean companies who are operating overseas and establishing a mechanism to ensure their respect for human rights, the response will be provided by the MOTI of Korea. And concerning the forced child labor, we'll also give you an answer. In the order of the people that I've mentioned, the responses will be given to you. My name is Yang Gi-yuk from the MOTI. First, I would like to thank you for posing so many questions. The Korean government, concerning the Korean companies that are making overseas investments, are trying to make sure that they respect human rights. And as a way to do so, we have established an NCP so that we can implement the OECD guidelines for multinational enterprises. First, this National Contact Point, NCP, is carrying out publicity and training for these Korean companies that are operating outside Korea. Regarding these OECD guidelines, we would like to make sure that these Korean companies have a high awareness of the importance of those guidelines. Starting from 2014, 18 times we have organized and conducted seminars and education sessions towards those Korean companies that are moving outside Korea. And at the same time, we have had explanatory sessions and workshops outside Korea, for instance, in China. This Korean NCP is encouraging these Korean companies that are operating overseas to respect human rights, and we are constantly monitoring them. And when there's a complaint with regards to the violation of these guidelines, we are making recommendations so that those complaints can be handled through mediation and arbitration. And we recommend them to comply with those guidelines. Now, let me talk about the effectiveness of the Korean NCP. Korean government has accommodated a recommendation from the NHRCK, and in September of 2013, we have realigned the Korean NCP. Experts from the private sector are now taking part in this independent NCP. And the Korean Commercial Arbitration Board was designated as a secretariat of the Korean NCP so that we can have better expertise for the operation. Thank you.
I am from the Ministry of Fisheries. As for the Korean flagged deep sea fishing vessel, in terms of the ill treatment that was committed against foreign seafarers, and what are the countermeasures and what are the legal remedies that we have in place to support them. First of all, in 2011, in the waters off of New Zealand, Korean deep sea vessel had there was an incident in relation to the human rights violations cases that occurred on the vessel, which involved foreign seafarers, and we really want to express deepest regret related to the incident. And as we are taking this as an opportunity to conduct an investigation jointly with other government bodies, and based on the results of the investigation, foreign seafarer human rights improvement measures have been put in place, and they're being enforced as we speak now. So let me go over some of the key contents of the improvement action plans. This includes operating a call center or hotline for foreign seafarers in order to provide counseling for their grievances, and also to provide education on human rights for the crews and the ship owner who are Korean, and also to install a provision on preventing forced labor, and also conducting fact-finding investigation on the current status of labor of foreign seafarers. Korean government, going forward as well, is going to continue to conduct fact-finding investigation on labor conditions of foreign crews on the Korean-flagged vessels, and will monitor implementation of the corrective actions. And if there are any opportunities for improvement, we will continue to work on them to address them. Also, when the allegation was first raised, there were some unpaid wages to the foreign sea crew, and we gave an order to the ship owner of the vessel to pay that unpaid wages to the foreign crews. And for those people that had allegations in terms of assault, they were prosecuted with the Supreme Prosecutor's Office. Thank you.
네, 산업부
My name is Yang Gyuk from MOTI. Regarding forced labor in cotton farms in Uzbekistan, I know that there is a considerable level of interest and concerns in the matter, and the Korean government is aware of that. Korean NCP, in July of this year, concerning the Korean companies, we have constantly monitored the circumstances, and utilizing all means possible, we have recommended those companies concerned to start working to improve human rights protection. In the case of the cooperation project with the World Bank, that effort will be one of those endeavors that should be made in this regard. And through various ways going forward, we are going to make efforts to improve human rights protection. Companies' overseas investment and their human rights violations. And as a countermeasure, with regards to the legal framework, we've already given you the responses in our responses to the list of issues. When companies make overseas investment, we're making sure that they respect human rights. And developing a national action plan in that regard is something that we are going to consider positively in the future. Thank you.
마지막으로
From employment and labor, I'm Lee Won-do. Forced about regulations and importing products that were made as a result of forced labor. against children. Korea has many trade agreements with a number of countries around the world. In this case, most of them follow the basic standards that have been defined by ILO as well as the core instruments thereof. And the trade agreements have provisions to comply with these standards that are set forth by ILO. And through this, we're trying to make sure that those countries that are counterpart to our trade agreements also comply with the provision on prevention of forced labor, which is defined by ILO, and we're making a lot of efforts to that end. Thank you.
네, 감사합니다.
Thank you very much. Mr. Iwazawa also posed another question regarding the support for unwed mothers. The response will be provided by the Ministry of Gender Equality and the Ministry of Education. My name is Choi Chang-heng from the Ministry of Gender Equality and Family. Regarding these teenage unwed mothers, in order to make sure that they continue with their school learning, we are providing and taking certain measures. And we're providing subsidies. For instance, in the case of an unwed mother who is below 24 in age, in order to make sure that they have the right to learning, we are providing subsidies. For instance, for child rearing subsidy and learning subsidy for high schoolers, and also allowances for self-support are provided. In particular, child rearing allowances, the amount of it will be raised, and rental housing for unwed mothers is also provided as a means of support. Through these endeavors, we are trying to encourage unwed mothers to raise their child, and we're trying to create a favorable environment for them to be able to do so, so that they can get on foot by themselves early on in their life. Throughout 58 locations throughout the nation, we have set up welfare facilities for unwed mothers, and we provide housing support and medical support for their childbirth. These are the activities that we are engaged in to support their child rearing. In addition, starting from March of this year, we are operating an agency for managing child care allowances. And this is an agency that offers one-stop services for unwed mothers in terms of filing and applying for child rearing support. Thank you.
예,
From the Ministry of Education, Kang Byung-gu. First of all, in relation to the youth who are forced to leave school due to pregnancy and child rearing, in school regulations, we're trying to make sure that there is a right to learning by the students. And if there are any provisions that actually lead to this violation, we are making sure that those provisions are deleted from the school regulations, and we gave guidance to our relevant schools. We're also providing training and education to civil servants that are working at each education office across the country to make sure that such guideline is implemented. And also for student unwed mothers, regardless of their pregnancy as well as child rearing, we're trying to make sure that they can continue to learn as they wish. So we're assigning different private education facilities that are commissioned by the government to make sure that they provide an environment for these unwed mothers, the students, can continue to learn. Thank you.
다음 질문은
Next question was with regards to LGBTIs and homosexuals. First, regarding the Korean government's position on LGBTIs, a response will be given by the Ministry of Education.
예, 그러면은 먼저 군대 내
First, concerning the human rights educations involving LGBTIs, a response from the MND will be given to you first. My name is Jin Young Park from the Ministry of National Defense. Regarding the human rights education in the military, I would like to give you some explanation. In 2014, after this case involving a death resulting from assault, as a way to prevent such cases, the MND has started to offer a human rights education. And starting from 2015, we have included such human rights education as part of regular curriculum. In cooperation with the NHRCK of Korea, we are now utilizing human rights officers and instructors to offer such education on human rights protection. At the same time, in consultation with the Ministry of Strategy and Finance, we have increased the budget for such education so that we can expand such educational activities within the military. As a result of such continued efforts to provide a human rights education, as of 2015, assault and ill treatment and the human rights violations thereof, the number has decreased significantly from 1 year ago. Thank you.
감사합니다.
Thank you. So we will go back to the previous question related to the same-sex education in education guidelines. In terms of LGBTI, especially for the same-gender sex, is a matter that requires a social consensus. So for elementary school and middle schools in the country, this information has not been included in the guidelines and the standards for sex education at these schools. However, human rights-related issues are currently being addressed as part of the curriculum. For example, a subject of morality, ethics, as well as health, relevant curricula at schools deal with the concept of LGBTI and also an importance of respecting their human rights. So we provide guidance and directions to our students in relation to LGBTI rights in school curriculum. Thank you.
네, 고맙습니다. 다음
Thank you. Concerning LGBTIs, their gender correction, a response will be given by the MOJ of Korea. My name is Minji Kim from MOJ. Let me address the question posed by Mr. Iwasawa. Gender correction of a transsexual is handled and processed based on the court's permission. Gender correction requires a permission from the court, and you need to satisfy certain requirements for gender correction. And gender correction is available regardless of your gender. And to talk about the requirements, first, the court requires transsexual persons to receive sex reassignment surgery and have the body of the other sex, including exterior genital organs, and not to have minor child, and not to be in marital relationship. Of these requirements, the requirement of not having an underage child is for the sake of the welfare of that child. And at the same time, it is also to ensure the best interests of that child. As such, we do not have a plan to make a revision to that provision. Regarding the legal status of that underage child and the society's perception as to that, I believe that given those aspects, we cannot allow that to be changed yet. And if you have an underage child, transsexuals, a request for gender correction is not allowed. Again, that is because we give priority consideration to the welfare of the child who is minor. And if that child's mother or father has a new gender, if that happens, the child will be shocked. And we would like to protect that child from having to go through such a shock. And I would like to ask for your understanding on that. Thank you.
네, 감사합니다.
Thank you. Next question was related to the nationality of marriage migrants. In relation to that, the question will be answered by the Immigration Office from the Ministry of Justice. Yes, I'm from MOJ. I'm Sung So Young. For example, if a marriage migrant is suffering from domestic violence by the Korean spouse, if the marriage migrant is not at fault, sojourn can be extended, and a person can also get Korean citizenship. For example, if the reason for divorce is proved to be the Korean spouse's fault, the marriage migrant woman is permitted to stay. In 2014, January 22nd, the Nationality Act was revised to make sure that the marriage migrant can receive a nationality. However, if a marriage migrant, starting from May 2010, would have to maintain normal marriage or married life so that she can be ensured a double citizenship, especially in relation to the Korean spouse's fault, starting from 2006, not only in the court rulings, but also many of the confirmation letters that were published by the civil society groups. You can confirm that information against that. And the marriage migrant, the woman, will be able to get extended stay in the country and also get dual citizenship. Let me now talk to you about extending their permit to stay in the country. In 2011, April 5th, in order to protect the human rights of marriage migrants in Korea, Immigration Control Act was revised. And if a marriage migrant, due to domestic violence, can file a lawsuit with the court, and if there's an investigation by the police on the allegations of domestic violence, until the procedure is completed, a marriage migrant can get an extension in the sojourn in the country. Also, in 2014, December 30th, Immigration Control Act was amended to make sure that if investigation has to continue as a result of the act on sexual crimes, so special privileges are given to the marriage migrants as they are given to the victims of sex crime in order to protect the rights, the human rights of women. Thank you.
다음 질문.
Thank you. The next question is women's participation in high-ranking positions. Answers will be provided by the Ministry of Gender Equality and the Ministry of Labor. My name is Chang Heng Che from the Ministry of Gender Equality and Family. Mr. Iwasawa raised a question concerning this aspect, that women's participation rate in high-ranking positions in the private and public sector is low, and the main measures that we are taking to address this issue. In order to enhance female representation in the public sector and private sector, let me address this aspect separately concerning this private sector and public sector in giving you these answers. First, in the case of the public sector, political parties are asked to nominate women for 50% of the seats for National Assembly seats and local councils. That is for proportional representation. And also in the case of the municipal and local assembly councils, 30% of the candidates should be appointed. The female, 30% should be given to female candidates. That is a recommendation that we are making. And at the same time, concerning the second plan for gender equality promotion, this quota system is proposed as a mandatory requirement under law. In order to increase females' representation in high-ranking positions in the public sector, managerial positions, in the military and police and teachers, and in the public sector positions and government agencies, to cover these sectors, we have come up with a plan to increase female participation in the managerial positions in these sectors. And through this plan, by the year 2017, every year we have set targets that need to be achieved annually. And every year we are making sure that the implementation status is monitored. We also have a plan for increasing female representation in the positions grade 4 or higher. And we are pursuing a policy of increasing women in high positions in the government. Now, let me shift my gears to the private sector. Female workers in the private sector and managers. For instance, if the rate of women in those positions in the private businesses, if the rate is below 70% of the average rate across all Korean businesses, affirmative action measures should be taken, and non-conforming businesses and workplaces will be disclosed through a name and shame system. In order to enhance capacity of female managers, we are also operating the so-called Women Talent Academy. At the same time, we have a female talent database system. In 2013, 63,000 women were on the database. Thank you.
고용노동부
Kim Jong-ho from the Ministry of Employment and Labor. What I would like to talk about is related to the corporate culture that is mainly dominated by men and the woman's share of childcare. The Korean government, in order to ensure increased participation of women and labor economic activities, is now working to expand work-family balance policy. For example, child care leave system is being expanded, and also we have introduced a system to provide the women to make claims for the child care leaves, and also to increase the men's participation in child care. We're also providing various incentives for them to take child care leaves, and such incentives are going to be expanded next year. In addition, in order to improve corporate culture, we have a certification system for family-friendly companies. We're also waging a campaign. And as a result of these efforts, women's economic participation is increasing. And also wage difference between men and women is decreasing. Thank you.
수석 대표입니다.
I'm the head of the delegation. The Korean government's commitment to human rights protection is firm, more firm than ever. There are many laws and regulations that we've already mentioned to you, but realistically, in order to make sure that these efforts lead to actual results, we are making our best efforts. In the process of the government's decision-making, those from the private sector are taking part in many of the committees that are in operation. As to the composition of such committees, we are making sure that no one gender is represented more than 60%. And at the same time, as to one gender's representation in professional jobs, we're making sure that there is balance. And at the same time, and if you look at the gender composition of groups that could go all the way up to high-ranking positions, most of the cases, one gender share is always always pretty close to 50%. So there's a balance. When it comes to child rearing, or for any other reasons, women's economic activities could become difficult, but in order to prevent that from happening, the government will do its utmost. Thank you.
네,
Next is related to marital rape. Answer will be given by the Women's Human Rights Policy Bureau at MOJ. I'm Hong Jong-hee from MOJ. and responsible for women and child human rights related policy, and I'd like to thank the member of the committee for posing me the question. So here are my answers to the question. According to Article 297 of Criminal Code, there's a provision on punishment of people that have raped other individuals. According to these laws, the object of rape has changed to. Excuse me, there's no provision that excludes rape among spouse. So we can say that the spouse can become the object of rape. In relation to this, in May 2013, the Supreme Court of Korea had a unanimous ruling on this matter, and according to civil code, even if there's an obligation to cohabitate, if there's an assault, if there's an intimidation, which lead to forced intercourse, the person involved in the marriage does not have to tolerate that kind of obligation. At the time, the Supreme Court gave a decision on the criteria of assault and violence, which would constitute the crime of rape. There was an adjudication by the court. For example, a course that is leading to the rape and the usual the sex behaviors between the spouses, and also situations after such incident occur. All these different factors would have to be considered comprehensively in order to make a decision on the marital rape. Going forward, by referring to the court's ruling on specific incidents of marital rape, I believe our position on this will become more clear. Thank you.
네, 이화사
The last question posed by Mr. Iwasawa was with regards to child abuse. Ministry of Health and Welfare will give you a response. My name is Hu Nam from the Ministry of Health and Welfare. Regarding an increase in the number of child abuse reports, let me explain why. The number of child abuse reporting is increasing, partly because of the increase in the actual occurrences of such cases, but child protection institutions and the police are now more actively involving themselves in investigating these and uncovering these, and there's an improvement in the people's awareness as to this type of activity or crime. Secondly, child protection institutions have certain infrastructures. As you mentioned, these child protection institutions have the difficulty of having sufficient resources, and starting from 2015, the government is working together with the local governments to help child protection institutions be equipped with adequate resources, and this has become a national project. And at the same time, 25.2 billion won was secured as a budget in this regard to expand the infrastructure related to child welfare. We're also working together with the private sector entities. For instance, private sector companies are providing child protection institutions with emergency vehicles and computers and IT equipment. Thank you.
예, 다음으로
Next, From Ms. Margot Watwa, a question will be answered by the following. First is related to the legislation of comprehensive anti-discrimination law. MOJ Human Rights Policy manager will answer the question. From MOJ, I'm the director, I'm the general, Kim Jun-yeon of Human Rights Bureau, Policy, excuse me. So I'd like to thank you very much for your interest in our human rights policy, and thank you very much for your question as well. As there was a recommendation by UN on legislating anti-discrimination law, the Korean government has been making a research and study as well as a review on legislating a comprehensive anti-discrimination act starting from 2012. In the NAP National Action Plan for Promotion and Protection of Human Rights, the legislation of Human Anti-Discrimination Act has been included. And in 2013, even in the government's policy agendas, legislation of a comprehensive anti-discrimination act has been adopted as a policy agenda, and there was a review on that policy. And as a result, the MOJ set up a task force on conducting a research and taking relevant initiatives and efforts to pursue such legislation. In anti-discrimination law, there are issues related to the reason of discrimination, the remedies, and the scope. And such details have been reflected in the legislation. However, in the process of legislating the law, especially in relation to sex orientation, there are pros and cons between the general public. There was a lot of controversies among the general public that were for and against, including sex orientation in the legislation law. So it is true that the legislation is not making any progress at this point of time. In terms of social integration and in terms of human rights protection, Anti-Discrimination Act is needed, but anti-discrimination legislation is actually causing a lot of confusions and controversies among the public, so we need to make further effort to ensure a social consensus. That is why we are continuing to listen to the voices of different stakeholders in society in order to establish a social consensus on pursuing such legislation. Also, we're looking at other advanced countries' experiences in terms of having an excellent anti-discrimination laws in place, and we're continuing to refer to those cases. Thank you.
네, 혹시 시간
If there are questions that are unanswered due to time constraints, we will make sure that the responses are provided tomorrow. The next question is regarding the racial discrimination and some specific cases. The Human Rights Policy Division of the MOJ will continue to provide responses.
인종차별
So concerning your question on racial discrimination, let me try to provide an answer. First, with regards to the cases where racial discrimination has been punished, in 2014, in a bus, a foreigner heard hateful remarks made by a Korean national, and that foreigner victim filed a complaint, and the prosecutor's office charged that person with the crime of insult, and the person was subjected to a fine. The crime of insult is a crime that is constituted under the Korean law only when there is a complaint that's filed. That is the reason that we do not have a high number of such cases in Korea. There's not many punishment that's been rendered yet. Next, concerning racial discrimination and the type of criminal punishment that's in place and the government measures to address this issue. As of now, the act based on racial discrimination is not criminalized under the Korean law. It does not constitute a crime. However, regarding the assault or injury that's caused by racial discrimination, that act is punished under the Criminal Act of Korea. The racial discrimination as a motivation for a crime could influence sentencing process. If a foreigner is targeted for making discriminatory remarks or expressions, the crime of an insult or defamation could apply under the Criminal Act. And if that act satisfies the requirements of a crime, criminal punishment is imposed. And at the same time, through the internet, if you make a racially discriminatory remark, we have a telecommunications related law in place that could punish that person for the crime of defamation. And at the same time, we have an administrative procedure that's also in place. For instance, if there is a complaint that is filed due to some expressions that were made online, the KCC, the Korea Broadcasting Evaluation Board, will screen that content and take certain actions to take down those contents. And if there's a discriminatory remark that's made in broadcasting content, the screening and evaluation will be conducted, and the sanctions will be taken, and the results of such sanctions will be broadcasted to the viewers. Next, let me talk about the legislative efforts regarding racial discrimination. Up until now, there is no Korean law that has the same provisions that are compatible with the ICCPR. However, the Constitution of Korea and other individual laws of Korea do have provisions that prohibit such discriminatory acts that are provided for under the ICCPR. And the National Assembly of Korea is also trying to strictly punish such racially motivated discriminatory remarks and acts, and a related law is currently pending before the National Assembly. When it comes to the punishment of racially discriminatory expressions, we need to strike the right balance between criminalization and the freedom of expression. and such issue is currently under discussion. So we need to strike the right balance between the freedom of expression and the principle of legality. Thank you.
네,
Thank you.
Muchas gracias.
Thank you very much. The distinguished head of delegation was telling me that they had a lot of questions put to them and there are still answers to give. So what we will do is as follows. Tomorrow we will continue with the responses for a few minutes. We'll continue with the responses to the first lot of questions, and then once you have finished, colleagues can carry out follow-up questions and the questions for the second part at the same time, so that we can stick to the procedure and use time as best possible. I would ask all colleagues to try to focus on their interventions, make them concise, and also for the delegation to really concentrate on providing specific answers to the questions that have been put to them. I'd like to thank all of you very much, both members of the committee and the distinguished delegation, for your hard work. We will adjourn the meeting now. I'd also like to thank, of course, the conference services and the interpreters. And I would wish all of you a very pleasant evening. The session is adjourned. See you tomorrow.